Hi, everyone. Thank you for joining us and welcome to our OG Energy Education series. My name is Josh Peterson and I'm a senior attorney here at Oliva Gibbs out of our Houston office. I'm also joined by two of my colleagues, attorney Margaret Chavez, who's also out of our Houston office, and attorney Allie McCluskey, who is an attorney reporting to our Columbus office. Today's topic will cover fixed and floating non-participating royalty interest issues in Texas and Ohio. Here is our contact information. If anybody has any questions following this presentation, please don't hesitate to reach out to any one of us. As a quick introduction, I will cover mineral interest versus royalty interests, NPRIs, fixed versus floating. We'll then take a look at Texas cases. I'll start with two pre-Van Dyke cases, and then Margaret will cover the Van Dyke case and the series of cases that followed after that. Lastly, Allie will cover the Ohio line of cases dealing with this issue. So starting with kind of the basics here, what's the difference between a mineral interest and a royalty interest, and what does it matter? A mineral interest is going to include 5 severable rights. These are commonly referred to as the bundle of sticks. It's the right to develop, the right to lease, the right to receive bonus payments, delay rentals, and probably the most important, the right to receive royalty payments. A royalty interest is kind of different. It's derived from a mineral interest, but it's non-possessory. Whenever somebody owns a royalty interest without any of the other attributes of ownership, it's referred to as a non-participating royalty interest or simply an NPRI. And the distinction here is going to be very critical because it determines who has to join a lease, who's going to receive royalties, bonus, and delay rentals. Fixed versus floating NPRIs. Essentially, an NPRI is going to fall into 2 categories. The first is fixed, also referred to as fractional, and it's not going to change from lease to lease. So if we have a 1/16th royalty of all oil and gas produced and saved, that's going to give its owner a fixed 1/16th of gross production. It doesn't matter if the lease provides for a 1/8 royalty or a 25% royalty, it stays fixed at that 1/16th. The other type is a floating, also known as a fraction of interest, and it does exactly what it says. It's going to float or vary depending on the royalty amount in each specific lease. This is commonly expressed in conveyances as 1/2 of the royalty. Anytime we see a conveyance or reservation that has multiple fractions, more often than not, there's going to be some sort of disagreement as to whether it reflects a fixed or floating royalty interest. And these double and restated fraction cases typically involve fractions of 1/8 because historically that was the landowner's royalty that was very ubiquitous in almost all the oil and gas leases from that time period. The first case we'll look at is Bridges versus Ohl. In 1940, the Clattenhoff sold a 640-acre tract in Upton County to a Virgil Powell, but the grantors reserved an undivided 1/2 of the usual 1/8 royalty, being wholly non-participating. The reservation went on to say that if, as, and when production is obtained, the grantor shall receive 1/2 of the usual 1/8 royalty or a 1/16th of total production. So here we have multiple fractions and we also have a restated fraction. When the court looked at this, they looked at it holistically and not mathematically, and they held that the reservation unambiguously held that it was a 1/2 floating NPRI and that there was no other interpretation that could be reasonable. In reaching its decision, the court looked at a number of factors. First, the 1940 deed uses double fractions instead of a single fraction. Next, those fractions are multiples of 1/8. There's also this repeated reference to the usual 1/8, which often relates to a state misconception. And lastly, there's this prospective contemplation that the royalty is going to take place in the future, and that's reflected by the phrase, if, as, and when production is obtained. And this leads us to a state misconception, which is a theory that there was this once common misunderstanding that a landowner only retained 1/8 of the minerals in place after executing a lease instead of a fee simple determinable with the possibility of reverter. This is probably best illustrated just with a quick example, but if we have John Williams, who owns 100% of the minerals, and he signs a lease in 1951, John may think that he now owns 1/8 of the minerals, but instead he still owns 8/8 of the minerals with the right to receive 1/8 royalty. So we might see John use 1/8 as a simple, albeit incorrect way to reflect his entire mineral interest. The next case we'll look at is the Davis case. The facts here are a little bit more complex, but it starts with the Sesslers, who acquired the entire surface and mineral estate to a tract of land in 1908. In March of 1926, the Sesslers then execute an oil and gas lease. Several months later, in November of 1926, the Sesslers execute an instrument titled royalty deed to a W.H. Hahn. It's titled royalty deed, but it's actually a mineral deed, and all the parties agree that it was a mineral deed. Then, in May of 1939, the Sesslers execute a warranty deed to Roberts. The 1939 deed stated that a 1/32 of the oil and gas rights had previously been conveyed to W.H. Hahn, and that the conveyance did not include that conveyance. Additionally, the 1939 deed created a new reservation in favor of the Sesslers. Since 1939, no royalties had been paid to the Sesslers, and their successors finally filed suit in 2018. The court first looked at that 1926 deed. It initially conveyed a 1/32 interest into all the oil and gas and other minerals, and the 1926 deed stated that it was subject to a prior lease. But that deed went on to say that it covers and includes 1/4 of the oil royalty and gas royalty. That 1/4 fraction was also used 3 additional times throughout the instrument to describe the various interests conveyed. The court rejected any type of two-grant theory and held that it was the intent of the parties to convey a 1/4 mineral interest. So now the issue becomes whether that language in the 1939 deed effectively put the grantee on notice of Hahn's pre-existing 1/4. Now we have to remember the 1939 deed only referenced the 1/32 oil and gas interest, and that it had been previously conveyed. The court said that the parties' intent behind the use of that 1/32 fraction depended on whether they were operating under the estate misconception theory. If they were not, then the 1939 deed didn't provide adequate notice of the prior conveyance to Hahn. However, if they were operating under estate misconception theory, then Roberts, who was that grantee under the 1939 deed, he should have understood the meaning of that paragraph to mean that the Sesslers had previously reserved a 1/4 interest to Hahn. So ultimately, the court held that the parties were operating under estate misconception theory for several reasons. The first is the date of the deed, 1939. That's really the pinnacle of when the estate misconception theory was commonplace. Next, the 1/32 fraction, it's a product of multiplying 1/4 by 1/8. The court also cited the Texas Supreme Court case of Highsall, which told us that the reality is that the use of a 1/8 or a multiple of 1/8 in instruments undoubtedly embodies the party's expectation that future leases will have the same 1/8. And then finally, the court looked at the use of the double fraction in the portion of the 1939 deed that created a new floating NPRI. And so the 1930, I guess in conclusion, the 1939 deed did provide Roberts with sufficient notice that excluded the 1/4 mineral interest that had previously been conveyed to Hahn based on the estate misconception theory. And now Margaret will talk about the Van Dyke and the line of cases that follow after that.
Thank you, Josh. As Josh mentioned, I will be starting with Van Dyke versus Navigator Group, probably the most talked about case in 2023, or certainly one amongst the top talked about cases of 2023. I'm sure you're all familiar with it, but because this kind of lays the groundwork for what's to follow, in the recent litigation and the upcoming litigation. I'll do a deep dive on this case, and then I will review 5 cases which have followed. 2 notes before I dive into the slides. First, each of my slides will start with a takeaway. This is just a takeaway that I've taken away from the case, something that I've keyed in on and think is an important thing to look at. And 2, you'll see that each of my slides have lots of text. I assure you, I will not read through everything verbatim. I just wanted to make sure there was lots of detailed notes, should you like to refer back to the slides later, as these slides will be provided to you at the conclusion of the presentation. So without further ado, Van Dyke versus Navigator Group. The takeaway here is that antiquated instruments that use 1/8 within a double fraction raise a presumption that 1/8 was used as a term of art to refer to the mineral estate. However, this is a rebuttable presumption. The facts of Van Dyke are as follows. In 1924, George H. Mulkey and Francis E. Mulkey conveyed their ranch and underlying minerals to G.R. White and G.W. Tom. The conveyance contained the following reservation. It is understood and agreed that 1/2 of 1/8 of all minerals and mineral rights in said land are herein reserved to grantors. There were numerous conveyances, leases, you name it, that followed and reflected that the grantors and grantees each had an undivided 1/2 interest in the minerals. For 90 years after the original deed's execution, the parties, including new owners who succeeded in interest, remained true to the understanding that each party had an undivided 1/2 interest in the minerals. In this presentation and in the opinion, those parties whose interests were derived from the grantors are referred to as the Mulkey parties, and those parties whose interests derived from the grantees are referred to as the White parties. The case here began in 2013 when the White parties brought the trespass to try title action after Endeavor Energy began to pay royalties from its drilling operations to both parties in equal shares. Again, this stems from the understanding that both parties had an undivided 1/2 interest in the minerals. At stake in this case was at least $44 million in accumulated disputed royalties. The ownership of those $44 million in disputed royalties, the future royalties, also turns on the interpretation of the 1924 deed's mineral reservation. Again, we're looking at that language 1/2 of 1/8. The White parties argued that the double fraction is elementary arithmetic, their words, not mine, with no additional meaning, so that only a 1/16 interest was ever reserved. Mulkey parties, on the other hand, argued that the double fraction is a term of art in common use at the time the deed was drafted, and that this term of art reserved a 1/2 of the mineral interest. Notably, this case also touches on the doctrine of presumed grant. I won't really focus on that in this presentation, but I do recommend you look at that aspect of the Van Dyke opinion as well. So, the trial court held that only a 1/16 interest was reserved. The Court of Appeals affirmed this. However, the Texas Supreme Court held that the trial court and Court of Appeals erred in holding that the Mulkey parties did not have a 1/2 interest in the minerals. Accordingly, the Texas Supreme Court held that the Mulkey parties hold title to 1/2 of the mineral estate because the original deed so requires, and because the presumed grant doctrine, the doctrine I just mentioned, would remove any remaining doubt. Again, this presentation won't get into the presumed grant doctrine and that aspect of this case, but I do recommend you check that out. So, how did the Texas Supreme Court land at this decision, which differed from the trial court and the Court of Appeals? Well, they looked at the construction of the original 1924 deed. First, the court stated that a text retains the same meaning today that it had when drafted. The analysis is not going to turn on what we think 1/2 of 1/8 means today. Instead, we will look at the context of the mineral conveyance from 1924. Our analysis is going to be confined to the 4 corners of the document, and we will look at what the party's intended meaning was in 1924. So, the analysis must then begin with determining what the ordinary usage of the term 1/2 of 1/8 was. At the time the deed was executed, 1/8 was widely used as a term of art to refer to the total mineral estate. This is something that Josh had just previously mentioned. Therefore, the Texas Supreme Court reasoned that antiquated instruments that use 1/8 within a double fraction raise a presumption that 1/8 was used as a term of art to refer to the mineral estate. However, this is a rebuttable presumption. Now, the Texas Supreme Court doesn't give us much to go off of in determining how to rebut said presumption, but they do note that the rebuttable presumption must come from the document itself. And if the text has provisions, whether they be expressed or structural, that indicate that the double fraction was used as nothing more than a double fraction, the presumption will be rebutted. So again, just to repeat, the takeaway from Van Dyke versus Navigator is bolded here. Antiquated instruments that use 1/8 within a double fraction raise a presumption that 1/8 was used as a term of art to refer to the mineral estate. Throughout the presentation, I'll refer to this as the Van Dyke presumption. And again, I can't state this enough. This is a rebuttable presumption. So there have been a host of cases that have followed this landmark decision. I will now briefly touch on 5. I'll go into a little more detail on 4 of these, and we'll see how the courts have applied Van Dyke. First, we'll take a look at Royalty Asset Holdings versus Bayswater Fund. The takeaway here is that courts will apply basic grammar rules when interpreting parentheticals, which may be viewed as non-essential, as it was in this case. So we'll start here in Reeves County. In 1945, the grantors sold a tract of land in Reeves County to the grantee by warranty deed, and the royalty reservation was as follows. Except that grantors for themselves, their heirs, and assigns retain, reserve, and accept from this conveyance an undivided 1/4 of the landowner's usual 1/8 royalty interest, being a full 1/32 royalty interest. Again, I've bolded, italicized, and highlighted the aspect of this reservation that's at issue. The issue is whether the non-participating royalty interest reserved in the 1945 deed is a fixed 1/32 or a floating 1/4 royalty interest. Here, the court held that the 1945 deed reserved a floating 1/4 non-participating royalty interest. The court reached this decision because there was a double fraction with the term 1/8. Thus, the Van Dyke rebuttable presumption that 1/8 was intended to refer to the entire mineral interest applies. Here, the presumption was not rebutted. So there was nothing that parties could point to within the 4 corners of the document that pointed to the fact that the double fraction was nothing more than a double fraction. Of note, and this is what I found most interesting in this case, is that the court stated if we were to consider the parenthetical, quote, being a full 1/32 royalty interest, quote, in isolation, it implies a fixed royalty interest of 1/32. If a multiple fraction was intended to show a fixed royalty, then the parenthetical would merely be restating the prior clause. So, in applying basic grammar principles to the single fraction parenthetical, we must view it as a non-essential explanation of the multiple fraction clause. Moving on to Johnson versus Clifton, this is another case concerning land out of Reeves County. We have the takeaway that the estate misconception doctrine may apply in situations with a single fraction that is a multiple of 8, such as 1/16 or 1/32. The facts here are that in 1951, J.B. Young, Elizabeth Cornell, and H.D. Cornell conveyed several thousand acres in Reeves County, Texas, to W.H. Holcomb and J. Marvin Rape as grantees. The granting clause stated that the grantors were conveying an undivided 1/128th interest in and to all of the oil and gas and other minerals in and underlying the following described tracts of land. Again, what's at issue here is bolded, italicized, and highlighted to make sure we don't miss that. The issue is whether the 1951 deed conveyed a fixed 1/128th royalty interest or a floating 1/16th royalty interest. The court here determined that the 1951 deed conveyed a floating 1/16th. It reached this conclusion because it found it the only way to harmonize the conflicting fractions and give meaning to every provision in the deed. This is something that we'll see a few cases later. The 1/128th fraction is a multiple of 1/8. As such, the Van Dyke presumption is raised. The floating 1/16th interest interpretation, quote, reconciled the provisions in the existing lease clause which provide the grantees were entitled to a 1/16th royalty interest in existing leases, and that this interpretation reconciles the provisions in the deed's future lease clause, which provide that the grantee shall only receive under such subsequent lease or leases a 1/128th, 1/16th of the usual 1/8 royalty, part of all the oil, gas, and other minerals taken. So because we have the granting clause and we have the current lease clause and the future lease clause, we need to make sure that the same meaning is given to each, and the interpretation of a floating 1/16th interest was one way the court could harmonize all those three clauses in their meanings. Next, we have permaco royalties. The takeaway here is that the repeated use of the double fraction when describing the interest may point toward the intent to convey or reserve a floating NPRI. Here we're leaving Reeves County and we're looking at land in Ward County. In 1937, O.N. and Nellie Rogers conveyed a parcel of land in Ward County to John Bush, subject to the following reservation. I'm not going to read the whole thing, but you can see the highlighted parts. A 1/16th free royalty interest being 1/2 of the usual 1/8 free royalty. And later down in the deed, we have this same information repeated. 1/16th of the oil and or gas produced, saved, and sold from said land being 1/2 of the usual 1/8 royalty there. The issue is whether the 1937 deed reserved a 1/16th fixed royalty interest by multiplying the double fraction, as the Baron entities contended, or a 1/2 floating royalty interest by applying the legacy doctrine, as the Broomco entities contended. So the court here determined that the 1937 deed reserved a 1/2 floating royalty interest to the grantors. The 1937 deed contained not one, but two descriptions of the royalty interest reservation. Additionally, the court reasoned that if the grantors had meant to reserve a fixed 1/16th royalty interest, there would have been no reason for them to repeat this double fraction in not one, but two clauses when describing the royalty interest. Accordingly, the only way the court was able to give meaning to all of the deed provisions was to apply the legacy doctrine and find that the grantors used the 1/8 fraction as a placeholder for the royalty provided in the lease, believing that the royalty would always be 1/8. So this is the second case we've looked at here, where the court is trying to give meaning to all clauses within the deed. Next, we have Powder River Mineral Partners versus Cimarex Energy Co. And we are making our way back to Reeves County, Texas with this case. The takeaway here is that courts will look to other clauses in the deed, such as the existing and future lease clauses, when determining the interest conveyed. This is starting to sound familiar, right? In 1947, N.F. Chapman and his wife, A.S. Chapman, conveyed to Jack May a royalty interest in the oil, gas, and other minerals in and under the subject property in Reeves County, Texas. The 1947 deed contained the following fraction in the granting clause: an undivided 3/16. Subsequently, the deed again refers to an undivided 3/16 of all the oil, gas, and other minerals in and under the described land. And now for a third time, the deed again restates that we have the 3/16 of 1/8 of all the oil and or gas or other minerals produced and saved from said lease. So the issue is whether the 1947 deed conveyed a fixed 3/128th royalty interest as claimed by the Chapman successors, or a floating 3/16th royalty interest as asserted by the May successors. Here, the court held that the 1947 deed conveyed a floating royalty interest. It applied the Van Dyke presumption because we see the double fraction used, with one of those fractions being 1/8. Based on high-saw analysis in Van Dyke's subsequent reliance on high-saw, an instrument executed in 1947 clearly qualifies for this presumption, the presumption being the Van Dyke presumption. The court looked at the granting clause of the deed, which did not use the double fraction at all. Instead, the granting clause conveyed a 3/16 interest. This broad grant could not be harmonized with the double fraction found in the second paragraph if the intent of the double fraction was to only convey a 3/128 fixed royalty. The court noted that the appellees did not identify any language in the deed itself that could rebut the Van Dyke presumption that the intent of the double fraction was to convey a floating royalty interest. Finally, we have Thompson versus Hoffman. There's no takeaway yet for this case because this case was decided by the Court of Appeals prior to the Van Dyke ruling. As such, the Supreme Court remanded this case back to the Court of Appeals to have them apply Van Dyke. But again, the reservation language here at issue is this double fraction, an undivided 3/32 interest, same being 3/4 of the usual 1/8 royalty. So stay tuned to see how the Texas Court of Appeals apply Van Dyke to this case, and I'm sure there will be plenty more litigation that follows. That's all I've got for Texas, and I will now turn it over to Allie McCluskey, who will be going over the Ohio case law, and she'll do a compare and contrast of how Ohio differs from Texas in this type of application. Thank you.
Thank you, Margaret. Hello, everyone. Now we're going to dive into Ohio case law and fixed and floating royalties, which is really the Wild West or Wild Midwest on this issue. As you'll see, we have no hard and fast rules, no presumptions or theories like we have in Texas to aid interpretation. The interest conveyed or reserved will depend on the language in the deed and application of contract interpretation rules. So what are Ohio's contract interpretation rules? They're similar to Texas. Written instruments are to be interpreted so as to carry out the intent of the parties, as the intent is evidenced by the contractual language. The court must examine the language contained in the deed in question, the question being not what the parties meant to say, but the meaning of what they did say. And the terms of the written instrument, if the terms of the written instrument are clear and unambiguous, the court must give the words their plain and ordinary meaning. As for extrinsic evidence, the court will only look at it when the deed is ambiguous. And as you'll see, the court here appears to err on the side of unambiguous rather than ambiguous when looking at double fraction conveyances. And then when possible, the court will construe a contract to attempt to harmonize all of the provisions of the document rather than produce conflict in them. And you'll see the court do this a number of times in the following cases. So there are 3 cases that we'll discuss today that came out last year, all appeals from the Court of Common Pleas of Monroe County, Ohio. We have Moore Family Trust v. Jeffords, Crum v. Mooney, and Mineral Development, Inc. v. Swin Production, Ohio. In Moore Family Trust, the appellant, Moore Family Trust, sued asking the court to declare that an 1896 royalty assignment had expired, or that the assignment was limited to a fixed 1/16 royalty interest. The trial court granted appellee's motion for judgment on the pleading, dismissing the complaint for failure to state a claim, and the court held that the interest was perpetual and not limited to an 1894 lease, and therefore it was a floating 1/2 royalty interest. The language at issue in this case is here for you to read, and as you can see, it has 2 parts. The first being the full equal 1/16 of all of the petroleum, oil, and gas in and under the premises hereafter described that may be produced by virtue of that certain oil and gas lease entered into November 30th, 1894. And then the second part said 1/16 interest being the 1/2 part of the royalty to be set apart to made free of charge into tanks and pipelines receiving said oil, which is hereby conveyed to the grantee and to be reserved to them in any contract of lease hereafter to be entered by us or our assigned. So Moore Family Trust argued on appeal that the royalty is a fixed 1/16 interest, Moore Family Trust being the surface owner, and essentially asked the court to ignore the second part of the conveyance and urged the court to apply the rule that when a conflict arises between the granting clause and some other part of the instrument, the granting clause takes precedence. The Seventh District rejected this argument and held that the interest is a floating 1/2 NPRI, or half the royalty provided in any operative lease. So how did the court arrive at that conclusion? They applied standard contract interpretation rules to make sense and give meaning to all of the language. Remember, the court prefers interpretations that harmonize rather than create conflict. So the Seventh District in Moore said the court recognized that references to 1/8 and 1/16 and 1/2 in the same deed is common in Ohio, and even cited to the Texas case Highsaw v. Dawkins, that the 1/8 royalty is ubiquitous in old leases and conveyances. And looking at the language used in the deed, the court said that it has two parts: an interest in the royalty from an existing lease, which is clearly identified, and an interest in royalties from future leases, which is also referenced. So the court held that the only reasonable interpretation is that the deed conveyed a floating 1/2 NPRI. Takeaways from this case: this is really a softball case for a fixed and floating royalty interpretation. The language was clear and easy, and I'm pretty sure that most title examiners would agree with the interpretation. It was decided on a motion for judgment on the pleading. So really the court only looked to the deed itself and found the deed so clear that it wasn't worth continuing any further. Now the court goes into a couple of cases. The latter two cases we'll discuss where things aren't so clear. In Crum v. Mooney, the culprit here was an 1898 assignment of royalties. The language at issue was a conveyance of 1/2 part of his royalty, being 1/16 part of all the oil and gas in and under the following described premises. And note the word his there and the capitalization of the word being, because the court found those important. The trial court held that the interest was a fixed 1/16 royalty, and the Seventh District agreed. On appeal, the appellant argued that the interest was floating. The 1/2 clause would be superfluous if the S&R intended to convey a flat 1/16. Why mention a 1/2 at all? And the court should assume that the 1/16 refers to the royalty interest in leases at the time of the assignment, being 1/2 of 1/8, and that the 1/2 refers to the royalty interest in future leases. Appellee, on the other hand, argued that the interest was fixed because the word his fixes the calculation of the royalty at the time of the assignment, which we assume is the 1/8, the standard royalty at the time. And the second clause, being a 1/16, further defines the first clause and is not a separate clause. The appellee also stressed that there is no reference in the instrument to future or existing leases. And the Seventh District agreed with the appellee and the trial court and held that the interest conveyed was a fixed 1/16 MPRI. Why? Because the parties used closed rather than open-ended terms. His royalty, not any royalty or the royalty. And there's no mention of future and existing leases. So the parties did not intend the 1/16 to apply to existing leases only, and 1/2 as the future leases. It's all to be viewed as a whole. Also, the second clause is not subordinate to the first clause. It is its own sentence, despite the lack of punctuation. Note that being is capitalized. In the opinion here, the court compared language in a Texas case, U.S. Shale, where the court predicated its conclusion that the deed at issue conveyed a floating fraction of royalty based on its conclusion that a 1/16 reference was contained in a clause subordinate to the 1/2 reference. And that's not the case here, because the court says that being capitalized, it is its own sentence. And then the court went on to say that the two fractions can be harmonized without stripping the 1/2 fraction of its meaning. As then it's not superfluous. It makes sense if you assume that his royalty at the time of the assignment was the 1/8. So our takeaways from Crum v. Mooney, there's no reference in the opinion to any existing lease or any prior royalty reservation or conveyance. So the court assumed, given the language in the assignment, that the grantor's interest wasn't a 1/8. Also, note the court's examination was limited to the assignment itself. The court found it to be unambiguous and did not rely on any extrinsic evidence. And that may have been the parties never brought it up, never argued that it was ambiguous and external evidence should be permitted. It served as a good reminder for us as title examiners and analysts that sometimes you need to limit interpretation to the instrument itself, its four corners, and ignore other things happening in the chain of title that you may have already seen. And now moving on to our last case, mineral development v. SWIN production. At issue here were two royalty reservations contained in the 1936 deed that conveyed two contiguous tracts of land, one being 40 acres in Section 22, and the other being 40 acres in Section 16 in Green Township, Monroe County. The surface owners and mineral rights owners leased the oil and gas estate to Eclipse, now SWIN. Wells were drilled, and one of the NPRI owners, Mineral Development, Inc., sued seeking a declaratory judgment claiming they had been underpaid royalties. The language at issue is here for you to read. The court calls them the Clegg Western Reservation and the Clegg Eastern Reservation for the eastern and western portions of the land. The Clegg Western Reservation provided grantors hereby reserve and accept from this deed the 1/2 of the 1/16th, being the 1/32nd of the royalty of all the oil and gas underlying the above described tract of land. And at the time of this reservation, there was a prior reservation in effect of a 1/16th royalty that appeared in a 1911 deed, and the 1936 deed at issue here included the verbatim language from the 1911 reservation. And then the Clegg Eastern Reservation provided the grantors hereby reserve and accept from this deed the 1/2 of the 1/8, being the 1/16th of the royalty of all the oil and gas underlying the above described 40 acres. On cross motions for summary judgment, the trial court held in favor of SWIN and interpreted the interest as a 1/32nd and a 1/16th royalty, both further reduced by lease royalty. So on appeal, appellant argued that the interest was floating for both of the tracts, a floating 1/2 NPRI. In the alternative, they argued that the interest was a fixed 1/32nd and a fixed 1/16th, not further reduced by lease royalty. An appellee argued that the deed is unambiguous and reserved a 1/32nd of lease royalty and a 1/16th of lease royalty as to the respective tracts. And the 7th District said that the trial court got it wrong and agreed with appellant's alternative argument that the interest is a fixed 1/32nd and a 1/16th NPRI, not to be further reduced by the royalty provided in any lease. So how did the court come to that conclusion? First, it held that both deeds are unambiguous. There are two clauses separated by a comma. As to the eastern 40 acres, the court recognized that the use of 1/8 was ubiquitous, as it did in Moore and Crum, and they assumed that the Cleggs owned at the time all of the royalty interest. And given the historical reference to 1/8, presumably the royalty interest the Cleggs held in the eastern acres was of 1/8 interest. And with that in mind, the court reasoned that the first clause indicates reservation of what the Cleggs owned, being a 1/8, and the second clause merely restated the 1/2 of the 1/8 at the 1/16th, which is pretty common in old deeds. As for the western 40 acres, the court used the same reasoning, but additionally took into account the existing 1911 1/16th royalty reservation to conclude that the Cleggs owned a 1/16th at the time. Remember that the 1911 language was included within the text of that 1936 deed, so the court didn't need to look to any extrinsic evidence or any other instrument to make sense of the language in that Western Clegg or the Clegg Western Reservation. So what about the assumption that a 1/8 means a lease royalty? What can we take away here? The 7th District appears to have strong feelings about assuming that a 1/8 always means lease royalty. It rejected the presumption that a 1/8 is a term of art and shorthand for whatever royalty amount might appear in a future lease. And in doing so, it rejects creating any bright line rule like we saw in the Navigator case, because not all historic leases provided for a 1/8, like leases that provided for 1/8 royalty for oil and 1/2 for gas rentals. The court also cites other cases that deal with leases that have a 1/16th royalty or something else that's non-standard. So the court will assume a 1/8 royalty when doing so harmonizes language in the deed, but it will not go so far as to create a presumption that a 1/8 means least royalty in every instance. As a takeaway from the whole, all of these 7th District cases that we saw at the end of last year, we can take away that double fraction issues are addressed with standard deed interpretation rules. We have no hard and fast rules, no presumptions or theories to aid in interpretation, but there are a number of factors that we can look to when we're construing double fraction interest. The first being whether language can be broken up into parts, like it was in Moore, to make sense of the whole. Whether there are references to existing and future leases, and this one appears pretty significant. Sometimes it's the little words that matter, of the, all of the. Even though double fraction language seems confusing, the court and perhaps just the parties in these cases seem inclined to treat it as unambiguous, so no extrinsic evidence is allowed. We have no Ohio Supreme Court precedent on these issues and no pending appeals, so it's an area of law that we'll need to watch closely for changes. That's all I have for you guys. Thank you for attending our Energy Education Series webinar on fixed versus floating royalties in Texas and Ohio. We hope that you have enjoyed it and learned a thing or two. If you have any questions, please feel free to reach out. Also, we'd love your feedback and suggestions for future webinar topics. So thank you in advance for completing the survey when you log off today.